10.
And we are back. Richard Nixon live here in the Legal Lounge on CRN Digital Talk Radio, crntalk.com, special mailbag edition of the show. We love your cards and letters, you guys. Keep them coming. Richard Nixon at crntalk.com. That's Richard Nixon at crntalk.com. Also, we are broadcasting live on Facebook, facebook.com/crntalk/videos. We appreciate your comments there as well. We thank you so much for joining us. And we were talking about jury instructions and an interesting case involving an auto burglary and the implications therefore. And you brought up an interesting point that I would really like you to clarify a little bit, the difference between a reversible error and a harmless error.
Yes, thank you, Mike. Essentially what it means is that the Court of Appeals is there to find errors in law. In general, when defendant loses the case and he appeals the case to the Court of Appeals in state court, the only issue before the court is an error in law as opposed to facts. In other words, the Court of Appeals doesn't really review the facts of the case. The facts are pretty much determined by the trial court, and you're pretty much stuck with the results of that, unless there is absolutely no way that the jury or the judge in the lower court could have found the way they did under the facts. But in general, 98.9% of the time, the appeal is based on an error in law. Well, in this case, for instance, if you had, let's just say in general, you had 6 witnesses testify to A, and based upon that testimony, defendant was found guilty. On appeal, you find out that, well, maybe one of those 6, the testimony was not quite as firm as we had thought, and so the Court of Appeals might find that that testimony from that 6th person was not necessarily reliable, so they might strike it. Now, that's an example of an error in the lower court that should have found out about the error, but it's probably harmless in the sense that the other 5 were consistent with the defendants being guilty, so that would be an example of harmless error. That is to say, the Court of Appeals found an error in the lower court, but it was harmless. That is, it would not have affected the ultimate result of the case. On the other hand, if for some reason, let's just assume that the verdict is such that there's no way the trier of fact, the jury in the lower court, could have found for the prosecutor, then it's possible that the Court of Appeals would simply say the error is so egregious that there's no way, given this error, that this person could have been found guilty, and therefore they reverse.
So let me just get this straight. So you can, if you're convicted of a crime, you take that crime to appeal. You can't base your appeal on the actual facts of the case. You have to base your appeal on whether or not the law was applied properly. In
general, that's true. Like I said, unless the factual findings are so egregious that the court says there's no way that the fact finder could have done what they did. It's just not possible.
Is it practice? Have you seen this before? Is it possible for perhaps one court of appeals to find a harmless error, and then the next court of appeals, the higher court, found it to be a true error, a non-harmless error?
No, I don't think I've ever found that situation, Mike. In general, once the Court of Appeal has spoken, it takes a lot of chutzpah, if you will, to even try it again, to go up to the Supreme Court. Let's say once the appellate court has spoken, and they are the workhorse of the courts, they pretty much explain exactly why they decided what they did, and it's pretty unassailable. It's pretty difficult to go around their decision.
Mm-hmm. And the majority of these appeal cases, when it comes to harmless error versus reversible error, there's a lot of habeas corpus cases, right?
Exactly.
Yeah, for anybody that's out there watching Making a Murderer Season 2 on Netflix, very fascinating. A lot of interesting content about the appeals process, the Court of Appeals process, and also the habeas corpus. It's very interesting. If you're interested in the law, you should definitely check it out. We really appreciate that email, and that's a great explanation, Richard. We really appreciate that. So keep these emails coming, you guys. Richard Nixon at crntalk.com. That's Richard Nixon at crntalk.com. Jack, we really appreciate that note, and we're going to have more of your cards and letters right after the break, you guys. Stick around. You're here with Richard Nixon Live. If you have any questions, comments, or concerns, you can always give us a call, 818-818-6401. Also check us out on Facebook, facebook.com/CRN Talk. More of your cards and letters right after the break here. Richard Nixon Live in the Legal Lounge, crntalk.com, streaming coast to coast and around the world.
This is today's entertainment answer. What does Ryan Gosling say about duality of lives as he plays Neil Armstrong in the new biodrama First Man?
It's hard to communicate just how dangerous and how extreme these missions really were. There was a duality to it that's interesting just in a cinematic way, but it also is, I think, truthful to the reality of the extremes of their lives at that time.
First Man, PG-13, in theaters October 12th. For this entertainment answer, I'm Matt Mungle.
When you really want Italian food, you have got to get to Columbo's. Columbo's Italian Steakhouse and Jazz Club, Colorado Boulevard, Eagle Rock. It's that little neighborhood place you wish was down the street from you. What happened to summer? You turn around and it's gone. So what do? Solution. Either stop turning around or head on over to Columbo's and enjoy the most delicious steaks imaginable. Seafood that brings awe and wonderment to your happy little taste buds. Columbo family Italian recipes so special they're kept under lock and key at an undisclosed and secure location. Jazz every night and the world's greatest meatballs. Need I say more? Oh, but I will. Enjoy the summer and head on over to Columbo's Italian Steakhouse. Good Time Central. Columbo's, because it really is that little neighborhood place you wish was down the street from you. Columbo's. Mangia.
Were you scammed into signing a timeshare contract? And did you miss the part that said you have to pay for your great idea? Not only for the rest of your life, but when you're not here anymore, you get to pass this turkey onto your family for them to pay for the rest of their lives. Thanks, Dad. Don't burden your family down the road, and don't be stuck with expensive timeshare payments forever. Get out of your bad idea timeshare contract guaranteed, or pay nothing. Call Resort Release today and learn for free how their timeshare exit team can help you legally exit your timeshare contract. They've helped thousands of people, and they're A+ rated with a BBB. So if you feel scammed, get mad and get out of your expensive timeshare contract right now, guaranteed. Call NOW.
800-716-9903. 800-716-9903. 800-716-9903. That's 800-716-9903.
If Ernest Hemingway was alive today, would he say this to you?
Shakespeare, Mark Twain, Edgar Allan Poe, all great writers. And after reading your book, I simply must add you to the list.
Wait, you don't have a book yet. So make a free call to Page Publishing. Their expert staff can help you turn your book idea into a real book, a masterpiece that could someday make the bestseller list in hard copy and digitally all across the world. Page Publishing can help you completely take your idea for a book, write it, and publish it. So if you want to join the ranks of some of the most famous authors in the world, call now for a free information kit. Turn your book idea into publishing gold. Make a free call right now to Page Publishing.
800-378-3212. 800-378-3212. 800-378-3212. That's 800-378-3212.
You check things all the time. like your email every 10 seconds or your ex's Instagram. But what about checking something as important as your credit? Well, Discover makes it quick, easy, and best of all, free. Discover is now offering FICO credit scores to everyone for free, even if you're not a customer. And checking your score won't hurt your credit. We call it the Discover Credit Scorecard. And once you know your score, you should check to see if your current credit card is the best fit for you. Check your credit, compare your card. Go to discover.com/credit scorecard. Limitations apply.
And we are back. Richard Nixon live here in the Legal Lounge on CRN Digital Talk Radio, CRNTalk.com, Facebook.com/CRN Talk. We are so happy to be here. We are taking your cards and letters. You guys keep them coming. Richard Nixon at CRNTalk.com. That's Richard Nixon at CRNTalk.com. Also available on Facebook. Just search for Richard Nixon or search for CRN Digital Talk on Facebook. We will take your calls and cards and letters there as well. This next one, this is from Dimitri. Dear Richard and Mike, I love the show. I hear you guys talk about due process all the time. What is the deal with substantive due process? Thanks, Dimitri.
Oh, that's a very interesting question, because we know that we have due process mentioned in the Fifth Amendment and in the 14th. Now, the Fifth Amendment is part of the Bill of Rights, 1791, and it for sure applies, or was intended to apply, to the federal government only. The 14th Amendment, 1868, was intended to apply to the states. It was just after the Civil War, and there's no question that the 14th Amendment Due Process Clause was intended to direct itself to the states. Now, in both instances, the same language is used. The 5th and 14th Amendment Due Process Clauses both say that before you can take a person's life, liberty, or property, you must afford them due process. Now, process by its very nature means procedure. That is to say, if plaintiff is suing defendant for, let's just say, breach of contract for $5,000, the defendant has, in general, 30 days to respond to that claim or that complaint. So the procedural part is the 30 days. That is, the law that governs procedure would be the 30-day period during which defendant must or may answer. On the other hand, the substantive part of the due process is that under contract laws, so-and-so is the law, and so has a particular defense, and so on. That would be the so-called substantive part of due process. Again, this hair-splitting was created by the Supreme Court. It does not exist, as far as I know, in any congressional statement. It's strictly for convenience of the courts.
What's the rationale is convenience of the courts?
Yes.
Very, very interesting. And this substantive due process, I mean, we talk a lot about redundancies in the law.
Yes.
I know it's one of your big picadillos.
Right.
Redundancies in the law, and it's not logical. And so it seems like, why do we need to have the 14th Amendment and the Fifth Amendment saying pretty much the same thing, due process? It's all under the same umbrella.
Well, that's right. In fact, that's exactly one of the arguments for why the incorporation doctrine, which I'm sure most people remember from other sessions, the incorporation doctrine basically says that in 1868, when the Supreme Court looked at the Due Process Clause of the 14th Amendment, what it meant back going forward in the 1930s and 40s is that what Congress really meant to do was to apply the Bill of Rights, 1791, through the 14th Amendment Due Process Clause to the states. Now, I realize that's pretty convoluted, but that's a good example of how the court made the law. So it doesn't make sense that the 14th Amendment Due Process Clause would be necessary in order to apply the Fifth Amendment Due Process Clause to the states. I mean, it's an abandoning of common sense and a resurrection of politically correct reasoning.
Yeah, the Supreme Court rules on substantive due process in the 14th Amendment. But what's very interesting here is a couple of facts that a couple of points I want to hear your views on. Is that the Supreme Court usually looks to see whether the right at question is a fundamental right by explaining whether it's deeply rooted in American history and traditions. Who determines what's rooted in our histories and traditions?
Well, again, that's what writers will call legal fiction, because oftentimes the court pretends to know what is deeply rooted in the minds of the people when in fact they don't. It's a nice flowery phrase intended to satisfy the followers of the court. In general, the court makes up tests, and oftentimes, to my disappointment and many others, they kind of make up their minds as to who they want to win and who they want to lose in a particular case, and create a test to suit their own previously decided decision.
I want to talk about that, about predetermined decisions by the court, and there is a case that you wanted to highlight that really is an example of that, and that's Plyer versus Doe.
Yes.
Can you give us the background about that case?
Well, Plyer versus Doe was, I think, a 1982 case. It had to do with the state of Texas said that the Board of Education in a particular city there in Texas did not have to, if you will, educate children of illegal aliens unless they paid for their education. And of course the court said that their decision by a majority was basically that these children had a constitutional right to be educated. However, they did recognize that there are two basic tests that had been applied previous to this decision. One is the so-called rational basis test, which simply means, does whatever the government wants to do, does their particular law, is it sound and is it rational in its basis? If it is, then it's held to be constitutional and the state can do it. If, on the other hand, it involves either a fundamental right or a suspect class, then it's presumed, that is, the legislation is presumed to be unconstitutional unless, again, the state can show a compelling reason for why they need it.
And I want to hold that thought, Richard. We're up against a hard break right now, and I want to talk more about the relation and the differences, compare and contrast the rational basis test, the strict scrutiny test as well. I want to talk about the definition of a suspect class, because in the due process clause it says that the rights of, quote, discrete and insular minorities, unquote. And I just want to talk more about who determines what that language means and who it applies to, you guys. So stick around. We'll be right back. Richard Nixon here in the Legal Lounge. CRN Digital Talk Radio, streaming live coast to coast and around the world on crntalk.com. Also available on Facebook, facebook.com/CRNTalk. Also check out Richard's website, www.pres37th.wix.com/America. That's www.pres37th.wix.com/America, where you can order his fantastic book, America, An Illusion of Freedom. Be right back.
What are you going to do with your old car? You can try selling it, you could junk it, or you could donate it to Heritage for the Blind. Your car will be towed away for free, and your donation is tax deductible. Just call 1-800-785-9618. Heritage for the Blind accepts cars, vans, trucks, and boats. It doesn't matter if your vehicle runs or not. It will be towed away for free, and you'll be supporting those that need help. Heritage for the Blind is a nonprofit organization that helps the visually impaired live fuller lives. Call right now to donate your car, and as a special thank you for calling, you'll receive a free 3-day vacation voucher to many exciting locations. Call Heritage for the Blind right now, 1-800-785-9618. Donating is easy, and your vehicle is towed away for free. Plus, you'll get a free vacation voucher. Call now, 1-800-785-9618. That's 1-800-785-9618.
The smartest way for you to get the lowest prices on your plane tickets, domestic or international, is to call SmartFares, first or last, but you've got to call us before you book your plane tickets. Fly anywhere in the world, fly anywhere in the U.S., and SmartFares can save you up to 75% on your plane tickets. We have the lowest airline ticket prices on over 500 airlines, and you've got a great 12-hour 12-hour free cancellation window. Plus, with our live agent help, you can always get fast help and fast answers. So on your next trip, maybe today, maybe tomorrow, how about right now? Pick up your phone and call Smart Fares, plus save up to 75% on your plane reservation. So call right now. 800-915-2644. 800-915-2644. 800-915-2644. 800-915-2644.
Richard Nixon in the Legal Lounge, joined by Richard Nixon. He's a practicing attorney, noted author of America, An Illusion of Freedom, a scientist, a constitutional scholar, amateur Congo player, and classic car aficionado. We are so happy to be here. We are taking your cards and letters. We really appreciate all these emails. It's Richard Nixon at crntalk.com. That's capital R, Richard Nixon at crntalk.com. And we were finishing up Dimitri's question, and I wanted just a little bit more background about the rational basis test and the strict scrutiny test.
Good questions. Again, I may have rushed through it earlier, but a rational basis test basically means this. Now, again, these are tests created by the Supreme Court, not by Congress, but by the Supreme Court. And basically, the rational basis test usually applies to economic or social type subjects. And what it basically means is this, is that the law that the government wants, whether it's state or federal, is presumed to be constitutional. And unless the person complaining about the law can show some reason for why it's not rational, then there's a presumption that it is rational and it will meet constitutional muster, and therefore it's okay, and the law remains. On the other hand, the strict scrutiny test is just the opposite. It presumes unconstitutionality, and it's up to the government now to prove that it does need this law, that is, that it's the least compelling way, the least intrusive way to do what the government wants to do. And this is applied, this strict scrutiny test is applied in general to situations that involve either fundamental rights or a suspect class. A fundamental right is, and it's, again, these things are defined by the Supreme Court. We find that there's a fundamental right to vote, a fundamental right to procreate, a fundamental right to speak, and so on. Things that are mentioned in the Constitution are clearly fundamental rights. A suspect class, on the other hand, is an individual who contains certain immutable traits, that is to say a person's race, nationality, etc. Things that that person cannot change are considered suspect class. Suspect in the sense that if the government is trying to regulate vis-a-vis that class, there's a presumption that the government's law is unconstitutional. So those are the two basic extremes, if you will. And there is a third category that the court made up for in the Plyler case, and that is we had children of illegal aliens who wanted to be educated. They were in school, but they didn't want to pay for their education. And the state of Texas said, look, we need funds in order to pay for the schools. We think it's proper that the school district should be able to charge these kids for their schooling. Well, it's clear that Texas would have won on the rational basis test. That certainly makes sense, that the schools need money to operate. On the other hand, these children are not, there's no fundamental right to an education, and these children, being children of illegal aliens, they are not a suspect class, and therefore they would have, Texas would have won if the strict scrutiny test had been applied. But in order for the state of Texas to lose this case, which of course the Supreme Court had decided it was going to do, they created a semi-fundamental right and a semi-suspect class. And they clearly say in this case that this only applies to illegal aliens and their right to an education.
And only in this one case, right?
Yes, exactly. And so this is what the Supreme Court does. And again, Mike, you've mentioned this too. We're not saying that the Supreme Court is malicious or evil. They really think that what they're doing is for the good of the country.
Yeah.
And I fully understand that. These are educated, meaningful, intelligent people. However, they, in a sense, they kind of ignore the rest of us who are what this country is supposed to be about. It's supposed to be our country. And let's face it, the Supreme Court is part of the government. And here you've got 9 unelected people dictating to 310 million people how they will live under what conditions. And that's what I rail against, and so did, we're in good company, Thomas Jefferson.
Absolutely. Good old TJ. We love that email, Dimitri. Thank you so much. Richard, fantastic answer. And let's get to this real fast before the break. This is from our friend, from Connor Oakes, who actually is one of our great weekend talent on the Royal Oak Show. He sent this question in from via Facebook. Connor, thank you so much. Richard, any thoughts on the Stormy Daniels verdict?
Well, by verdict, are we talking about the fact that her case against Donald Trump, that is, her defamation case against Donald Trump, has been dismissed by the court?
That's correct. Judge Otero of the Central District of California dismissed Stormy Daniels' defamation action against President Trump under the Texas anti-SLAPP statute. And Richard, about a minute for the break, what is the concept of SLAPP and anti-SLAPP?
Okay, SLAPP means strategic litigation against public participation. And basically what it is, it's a dressed-up motion to strike, which means that someone who's exercising their First Amendment freedoms, like speaking, like saying things in public, either in writing or orally, that they have a constitutional right to do, if someone then sues them with the intent to stop them, to chill their freedom of speech, the question becomes, if they were to sue them for defamation or slander, whether or not we're going to allow the plaintiff in that slander case to proceed for 2 years before we find out that there was no basis for that lawsuit. In the meantime, the people who were speaking have been stopped from speaking. There is a thing called the SLAPP statute that deals with that.
Yeah, we're going to talk about this right after the break. Thank you so much for joining us. We'll be right back right after the break here. Richard Nixon live in the Legal Lounge.
Come to Angelo's and Vinci's Restaurante to see memorabilia of movie stars and theatrical magic right in downtown Fullerton, California. The Art of the Great Masters in an Italian town square complete with storefronts of old, Italian butchers and cheesemongers, fruit and wine vendors, seamstresses showing their wares, the romance of Romeo and Juliet. Find our mystical Room of the Moon, and don't forget King Kong, Dracula, Frankenstein, and who knows what awaits you in the wine cellar. Enjoy the great food. We hand stuff our pastas, roll each and every tortellini, bake our own bread, and make all of our sauces fresh from our private stock of Sicilian family recipes. Pasta to seafood, chicken to award-winning pizzas, tiramisu flown in from Rome. If you can't find something on our menu to tempt you, you don't like Italian food. Try our Sunday brunch, all you can eat, just $21.95. And Angelo's and Vinci's has been named the best Italian restaurant in Orange County 2 years in a row, and our owner has been named Restaurateur of the Year. Angelo's and Vinci's, Fullerton, California, 714-879-4022 or angelosandvinci's.com.
Do you owe back taxes to the IRS? News flash, the president has changed the tax laws, and now you may be able to pay the IRS less. If you owe $10,000 or more in back taxes, the tax doctor can help you pay the IRS as little as possible allowed by law. There are new tax laws for business owners, the self-employed, even W-2 workers. If you have a back tax problem or a few years of unfilled returns, new help to save you money is now here. Call right now to see how the new tax laws can help you. Plus, right now, we'll waive the consultation fee and give you a free tax savings report. Attention business owners, the self-employed, and W-2 workers. Make this free call to the tax doctor now and learn how to take advantage of the new tax laws that may help you pay the IRS less. 800-985-1610. 800-985-1610. 800-985-1610. That's 800-985-1610.
Still got those annoying critters? I'm talking bees and fleas, spiders, ants, roaches, bedbugs, and those disgusting rodents. Have you made that call to Dewey Pest Control yet? What's holding you back? Get rid of them, and I mean right now. When the heat brings them out, it's time to call Dewey, because Dewey knocks them down and keeps them out. Dewey's an 89-year Heritage California family business with 32 offices statewide. Think you got those 24/7 wood-munching termites chewing up your house? Call Dewey right now for their free inspection. And all this month, get $89 off with a regular maintenance program. Call 800-209-0900. That's 800-209-0900. Just one call to Dewey does it all. 800-209-0900. Or get your free inspection online at DeweyRadio.com. That's Dewey, D-E-W-E-Y, DeweyRadio.com.
And we are back here in the Legal Lounge. Richard Nixon live. I'm Mike Gary. This is CRN Digital Talk Radio, streaming live coast to coast and around the world on CRNTalk.com. Wrapping things up, and we want to talk about Miss Stormy Daniels and the concept called SLAP, and I understand that it's kind of funny to join those two terms together, Stormy Daniels and SLAP, based on her previous career. But Richard, can you tell us a little bit more about SLAP and anti-SLAP and how it's used to kind of stifle free speech?
Okay, so the hypothetical I like to use is someone picketing, let's say, outside of an apartment building, saying that the landlord charges too much rent. The tenants, if you will, are exercising their First Amendment freedoms, guaranteed by both the U.S. and the California Constitutions. And the landlord, in order to stop that negative advertising, if you will, files a defamation suit against these picketers, against the tenants. Now, if you just let it run its course, that is to say, go through discovery and so on, it might take years before the case ever comes to fruition and there's a final resolution of the case. In the meantime, these people who are afraid of being liable for large amounts of damages, they'll stop picketing. So their First Amendment freedoms to speak are essentially curtailed or chilled. So there's a process to curtail that situation, and that is, it's called a motion to strike, or in California, it's a 425-16 motion, or anti-SLAP. And what that means is, SLAP is an acronym, I should say, for Strategic Litigation Against Public Participation. Basically, what we're saying there is if the landlord brings a defamation action, the court will look at that complaint to see if there's any real legitimate basis for it. If the court determines that there is such a basis, they will allow the plaintiff, in that case, the landlord, to go forward. In many instances, what happens, though, is we find out that the landlord, in this case, only brought the action to stop the negative advertising. And therefore, if the court finds out that there's really no basis for that, and the court will construe all the facts in that case toward the plaintiff, that is, in this case, the landlord, construe it all in their favor to see if there's any possibility this landlord could prevail. If they find that the landlord could not, and in this case, in the Stormy Daniels case, the court found there was no way she could prevail against President Trump, given what he had said about her, then the defendant wins the case, and in this case it was President Trump. And the interesting part about this statute is that the prevailing party gets attorney's fees.
And this is rare. I mean, we've talked about this in previous sessions, and I always thought that, court costs, and attorney's fees would be paid, but it was actually just the court, like filing and whatnot, which is a drop in the bucket. But Miss Daniels and her attorney, Mr. Avenatti, who's had a rough week, they have to really pony up for Donald Trump. So basically, to recap here, Stormy Daniels said something about Donald Trump. Yes. Donald Trump said, what you said is not true.
Yes.
Stormy Daniels said, hey, you just called me a liar. You defame me. I'm suing you for defamation.
Right.
And then the court says, not so fast, Miss Daniels. No, ma'am.
Yes.
What he said was constitutionally protected speech. You got to pay his attorney's fees.
Basically, defamation, as defined in California and most states, is simply a false statement which tends to harm the reputation of the individual. In this case, what Trump said was, and I quote, after she had presented some kind of a sketch regarding the person who had, in a sense, threatened her not to go forward against Mr. Trump, President Trump, Mr. Trump's Twitter said, a sketch years later about a non-existent man, a total con job.
Yeah, and that Miss Daniels, sorry to hear about your loss there, sweetheart. We'll be back next week, you guys. Thank you so much for joining us here in the Legal Lounge with Richard and Nixon Live. We thank you so much for your cards and letters. Keep them coming. Richard Nixon at crntalk.com. Richard Nixon at crntalk.com. Richard, thank you so much.
Thank you.
And go Dodgers.
Glad to be here.
We'll be back next week, you guys, with more Legal Lounge here on CRN Digital Talk Radio, crntalk.com.
Which was most appropriate because that was your theme.